Donald Trump has spent 4 decades dodging the witness stand, but the clock has just run out, and the trap is officially sprung. We are currently witnessing an unprecedented collision of legal and political crises, starting with a massive ruling regarding the Supplemental Nutrition Assistance Program, widely known as SNAP, and ending with a historic federal court order that threatens to dismantle the former president's entire legal defense strategy. Right now,
infant formula, do we not pay for school lunches? What the real issue is here, my friends across the aisle need to come on back and fund the government again.
The president talks about the cost of living a lot. This is what he said on Fox just yesterday in reference to Tuesday's elections.
We've done so much. Energy is way down. Look at energy. We're going to have $2 gasoline. I did that. That brings everything else down. Groceries are way down other than beef. Now, beef is going to come down. We have to do that. The fact is we have prices way down. We have prices down. Our country's doing well.
So inflation, just as a factual matter, it's at its highest rate since January when President Trump took office. Groceries are up across all product categories, not just beef, according to the Bureau of Labor Statistics. Americans are paying close to $200.
42 million Americans rely on these vital food stamp benefits to survive the month of November, and they are caught squarely in the crossfire of what has become the longest government shutdown in the history of the United States. In the midst of this bureaucratic paralysis, the administration has formally announced its intention to appeal a groundbreaking judicial ruling. At this moment, the Trump administration is only partially funding the nutrition program through the end of November, drawing from a nearly $5 billion emergency reserve fund that they have been forced to tap into just to keep the system minimally operational. CNN's Caitlin Collins, reporting live from the White House, has underscored just how significant this judicial intervention truly is. The federal judge has explicitly ordered the government to disburse these SNAP payments in full, acting as a critical lifeline for millions of citizens who have been left entirely in the lurch. This vulnerable population has been suspended in a state of deep uncertainty while a fierce legal dispute plays out inside the courtroom, driven by advocacy groups suing the administration for its failure to deliver these essential benefits. The urgency of this situation cannot be overstated. During this crippling government shutdown, a specific detail in the judge's ruling stands out with blazing clarity. The court mandated that these payments must be made by this coming Friday, effectively drawing a hard line in the sand. The judge took pointed notice of statements the former president made on his Truth Social platform earlier in the week. This occurred just after the administration was initially ordered to pay roughly half of the SNAP benefits using whatever capital remained in their contingency fund. This maneuver triggered a wave of intense questioning during a White House press briefing where spokesperson Caroline Leavitt acknowledged the president's social media posts, but insisted that the administration was still functioning in compliance with the court's directives. Those specific arguments were actually coordinated talking points distributed to Republican lawmakers on Capitol Hill. However, the federal judge interpreted the situation entirely differently, viewing the president's rhetoric as a direct rebuke and an active defiance of the court's authority to mandate the funding. The judge issued a stark and terrifying warning stating that if these financial obligations are not met in full, millions of elderly and disabled Americans will face the immediate, horrifying reality of starvation. This intense humanitarian deadline forces the administration into a corner, leaving everyone wondering what their next strategic move will be as they prepare to officially appeal the decision handed down by Judge McConnell. The White House and the Office of Management and Budget have remained conspicuously silent on the matter, while the situation rapidly devolves into an acute crisis point for ordinary citizens. As the political maneuvering continues on Capitol Hill tonight, there is still absolutely no end in sight to this devastating government shutdown. Adding to the political friction, Republican Senator Roger Marshall of Kansas offered his perspective on the administration's decision to fight the judge's order. Senator Marshall argued that Republicans genuinely want to secure the SNAP benefits, pointing out that they have offered Democrats 13 separate opportunities to vote on funding measures, which he claims the opposition continues to reject. Marshall suggested that the administration's original intent was to utilize the $5 billion in emergency disaster funds, a move the judge ultimately validated, but he raised the broader systemic issue of fiscal prioritization. He questioned how the government should allocate its rapidly dwindling resources, asking whether funds should be diverted from military payrolls or infant formula and school lunch programs to cover the shortfall. Marshall aggressively pivoted the blame toward his colleagues across the aisle, demanding they return to the negotiating table to broadly fund the government. The economic context surrounding the standoff is heavily contested. Just yesterday, during a Fox News appearance referencing recent elections, the former president boasted about his economic record, claiming that under his leadership, energy costs were drastically reduced to $2 a gallon for gasoline, which consequently drove down the price of all other commodities, including groceries. He insisted that aside from the price of beef, which he promised would eventually stabilize, overall costs were dropping and the country was thriving. However, the factual economic reality paints a vastly different picture. Inflation is currently surging at its highest rate since January of the year the administration first took office. According to the Bureau of Labor Statistics, grocery prices have skyrocketed across virtually all product categories, forcing the average American family to pay nearly $200 more for the exact same basket of goods and services compared to the previous year. When pressed on whether these statements indicate a severe disconnect from the daily financial struggles of the American public, Senator Marshall conceded that the situation could be improved. He pointed to a difficult inherited economic landscape, citing 4 years of cumulative inflation reaching roughly 25%, but attempted to highlight a silver lining by claiming that current wage growth is finally outpacing the inflation rate. While acknowledging that gasoline prices have indeed fallen from their peak and interest rates are showing signs of cooling, he admitted that significant work remains to be done regarding the soaring costs of healthcare and housing, issues he attributed directly to policies left behind by the Biden administration. Yet, as massive as this economic and legislative standoff is, it is rapidly being eclipsed by a legal earthquake that is shaking the very foundations of Donald Trump's defensive architecture. For decades, his legal playbook has been ruthlessly consistent and overwhelmingly effective. The strategy is simple but expensive. Appeal absolutely everything, aggressively claim every conceivable executive and legal privilege, challenge the validity of every single subpoena, relentlessly request extensions for every filing deadline, intentionally run out the clock, and financially and emotionally exhaust the opposition. The ultimate goal of this methodology has always been to push any prospect of real, tangible accountability as far into the distant future as possible, thereby making the sheer cost of pressing forward too massive for most adversaries to bear. This strategy of attrition has been built, tested, and refined across hundreds of vicious legal confrontations spanning 4 decades of high-stakes business and cutthroat political life. However, this seemingly impenetrable fortress of delay and deflection has one specific, glaring, and mathematically fatal vulnerability. There is one distinct scenario that this entire defensive architecture was desperately designed to prevent at all costs. That scenario is Donald Trump sitting completely alone in a witness chair under oath, compelled to answer highly specific, granular questions on the public record. In this terrifying scenario, there is no team of highly paid attorneys stepping in to interpret or deflect the questions on his behalf. There is no polished press release drafted by communications experts to serve as a substitute for a direct answer. There is no ability to file a last-minute motion to dismiss the inquiry before he speaks. There is only the witness, the solemn oath, the relentless questioning of the prosecutor, and the absolute certainty that whatever words come out of his mouth next will become a permanent, indelible part of the sworn legal record of the proceeding. Tonight, a federal judge has ordered exactly that nightmare scenario into existence. This is not an order scheduled for 6 months from now. This is not a demand that will inevitably be paused after the next agonizing round of endless appeals. The judge has ordered him to show up, sit down, take the oath, and answer the questions in 48 to 72 hours. The only alternative to compliance is facing immediate contempt of court, which carries the explicit and authorized threat of being taken into custody by the United States Marshals. This is a scenario that has always existed as the theoretical distant endpoint of every accountability proceeding he has ever faced. But tonight, it has transformed into an immediate, unavoidable reality. Trump is legally frozen. There is absolutely no procedural maneuver, no hidden loophole, and no emergency filing available that can successfully extract him from this specific room on this aggressively compressed timeline. We have already seen a glimpse of what this looks like. The New York civil fraud trial recently gave the world a raw, unfiltered preview of what Donald Trump actually looks like when forced to speak under oath in a hostile environment. It is profoundly different from the tightly controlled, carefully managed, teleprompter-driven performance of a politician reading a prepared statement at a bustling press conference. His unscripted testimony is consistently unfiltered, wildly contradictory, and deeply inherently damaging to his own legal standing. He is fundamentally unaccustomed to operating in any setting where he cannot dominate the room, control the overarching narrative, verbally redirect the flow of the conversation, or simply refuse to answer a question and dramatically walk away. But if the New York civil fraud testimony was merely a preview, the compelled federal testimony ordered tonight is the undisputed main event. Every single legal analyst who observed the dynamics inside that New York courtroom implicitly understands why the prospect of an expanded, deeply comprehensive sworn testimony is so incredibly perilous. This new order does not just cover the civil fraud allegations. It comprehensively blankets the obstruction of justice probe, the mishandling of classified documents, the sweeping election interference investigations, and every other active legal proceeding where his direct testimony holds legal relevance. This is precisely the apocalyptic scenario his legal team has spent years and hundreds of millions of dollars in donor contributions trying to desperately avoid. The oath itself is the ultimate vulnerability, and tonight a federal judge has marched him directly into it with a deadline that his legendary delay strategy simply cannot absorb. The 48 to 72 hour timeline attached to this order is not some arbitrary administrative detail. It is, in fact, the most crucial and weaponized element of the entire judicial directive. It was mathematically calibrated to completely foreclose the delay mechanisms that his legal team has successfully weaponized to extend every previous confrontation involving compelled testimony. Under normal circumstances, the timeline for challenging a testimony order through the appellate process is a slow, methodical grind. It involves drafting and filing a motion to stay the order, carefully briefing the massive appeal, waiting for the appellate panel to coordinate their schedules, setting a date for oral arguments, and finally waiting for a written ruling to be issued. This traditional process takes weeks at the absolute minimum and very often stretches into several months. Trump's lawyers have utilized this specific appellate timeline strategically, predictably, and repeatedly to push dangerous testimony deadlines far past the point where they could inflict any meaningful consequences within the relevant legal or political news cycle. The 48 to 72 hour deadline is surgically designed to make that traditional appellate strategy entirely impossible to execute. If his team attempts to file an emergency motion for a stay within 48 hours, knowing that a contempt order and US Marshal custody are the immediate alternatives to compliance, they are forcing an emergency appellate response. Appellate courts are historically and institutionally extremely reluctant to grant emergency stays on such a compressed timeline without a definitive showing of catastrophic, irreparable harm that clearly outweighs the competing interests of the justice system. Furthermore, the judge who issued this explosive testimony order has already comprehensively ruled on every conceivable privilege claim the defense could muster. The judge has meticulously documented these rulings in the official record. In order to grant a stay, the appellate court would essentially have to completely reverse the district court's carefully reasoned, already issued rulings on an emergency basis, with absolutely no opportunity for oral argument and no time for full legal briefing. This is a legal standard that is extraordinarily, almost impossibly difficult to meet in just 2 to 3 days, even for a flawlessly resourced legal defense team staffed with the finest appellate lawyers in the country. Consider the profound implications of this reality. A legal strategy that has for decades depended entirely on the generous timeline of the appellate process as its primary mechanism for converting a fundamentally losing legal position into an extended, indefinite delay is suddenly entirely useless. When the timeline collapses, the strategy collapses with it. A delay strategy that cannot actually function within the available time given is no longer a strategy at all. It is simply a surrender waiting to inevitably happen under the most unfavorable and hostile terms imaginable. And the sheer scope of the mandated testimony matters enormously. The judge's order does not confine the questioning to one isolated event. It simultaneously covers multiple massive active investigations. It encompasses the intricate fraud and obstruction investigations that form the primary basis for the order, but it aggressively expands to include the complex financial valuations, the bizarre document handling protocols, and the intimate, highly sensitive conversations held with political advisors, defense lawyers, and various co-defendants. The prosecution will demand to know exactly what he knew, the precise moment he knew it, and what specific instructions he issued to his subordinates in direct response to that dangerous knowledge. He is not being asked to sit down and recount a single bounded set of historical facts. He is being ordered by the federal court to sit under oath and systematically traverse the entire sprawling breadth of his active legal landscape. This comprehensive scope is what makes the impending testimony session so uniquely lethal. Beyond the simple danger of being placed under oath, inconsistencies across different, seemingly unrelated subjects during a single marathon testimony session are incredibly easy for prosecutors to document and devastatingly easy to prosecute as direct perjury. This is vastly more dangerous than minor inconsistencies that slowly emerge across multiple separate proceedings separated by years of time. A single, exhaustive sworn session creates one unified, permanently binding record of exactly what he claimed about every single scandal simultaneously. That unified sworn record instantly becomes available to prosecutors working on every single active proceeding across the country. It acts not just as a piece of evidence in one isolated trial, but as a universal cross-cutting resource that can and will be aggressively used to test the consistency of every single defense argument his team is currently mounting in every other courtroom. The protective shields have already been shattered. The judge has firmly ruled that executive privilege simply does not apply to the specific categories of communications the prosecutors intend to explore, determining that these interactions involved private, personal, and political campaign conduct rather than the execution of core constitutional presidential duties. The crime fraud exception to attorney-client privilege has been explicitly invoked, meaning that the communications in question were allegedly utilized to further ongoing criminal acts rather than to seek legitimate legal counsel. Even the work product doctrine has been tossed aside, failing to shield materials generated in connection with the very conduct under criminal investigation. Because the district court has produced heavily reasoned, detailed written decisions systematically dismantling each of these specific legal defenses, the appellate pathway is effectively blockaded, the privileged doors are nailed shut. Without those procedural escape hatches, the only remaining responses left on the table are total compliance or federal contempt. The perjury dimension of this crisis is where the situation transforms from dangerous to truly catastrophic. Whatever is spoken under oath in that room over the next 48 to 72 hours is not contained. It is a sworn, unalterable record that immediately exposes the witness to massive criminal liability for every single false statement made. The federal perjury statute is a brutally simple legal mechanism, especially when applied to a public figure who has spent years loudly broadcasting contradictory narratives across a multitude of legal, public, and political forums. To secure a perjury conviction, federal prosecutors only need to prove that the witness made a false statement under oath concerning a material matter relevant to the proceeding, and that the witness knew the statement was false when they made it. The sprawling documentary record that investigators have meticulously assembled spanning the Mar-a-Lago classified documents raid, the sweeping Georgia and federal election interference probes, the New York civil fraud proceedings, and thousands of pages of cooperating witness testimonies acts as a comprehensive, inescapable archive. It details exactly what he and his inner circle have said, done, and privately communicated about every major factual question that will be raised in that chair. This massive archive is the ultimate perjury trap. It is not a trap maliciously set by corrupt prosecutors. Rather, it is a trap built entirely by the crushing weight of the documented record itself. When a witness with a long history of inconsistent public statements is finally locked into a chair, placed under oath, and forced to provide one definitive, legally binding account of reality, every single syllable uttered is instantly cross-referenced against mountains of emails, texts, and internal memos. Every answer that diverges even slightly from the established documentary evidence is a brand new, highly prosecutable felony count. Unlike political rallies or cable news interviews where inconsistencies carry absolutely no direct legal consequence, this sworn session creates a definitive artifact that can be used to destroy him, regardless of how his team later attempts to spin the context or subjective meaning of his words. If he chooses to defy the order, the contempt scenario plunges the nation into uncharted constitutional waters. The judge's explicit written authorization allowing the United States Marshals to take custody of the witness is not a bluff or a rhetorical flourish. It is a highly specific, immediately operational directive that the Marshal Service is fully prepared to physically execute the moment the deadline expires without compliance. The Marshals serve as the independent enforcement arm of the federal judiciary, entirely separate from the executive branch. Their constitutional authority to enforce a valid federal court order, including physically detaining a subject to compel their compliance, does not require the permission, agreement, or cooperation of the Secret Service. This creates a terrifying institutional showdown. The foundational authority of the judicial branch to enforce its rulings is the bedrock of the separation of powers. If a former or sitting president blatantly defies a federal court's mandate to testify and triggers a marshal custody order, it forces the ultimate constitutional stress test. Will the Secret Service physically stand between federal marshals and the subject they have been ordered by a judge to detain? The legal framework is clear. The courts have the absolute right to enforce their orders, and no individual is above the law, regardless of the protective mission of the Secret Service. Legal scholars describing this 48 to 72-hour window as a make or break moment for the Republic are not engaging in sensational hyperbole. They are accurately describing the explosive dynamic of compelled testimony. Documentary evidence always requires interpretation, and cooperating witnesses must survive cross-examination, but a defendant's own sworn testimony is the most devastating, unmediated form of evidence that exists in the American legal system. If he answers truthfully, the documentary record ensures he directly incriminates himself in his own words, immediately arming prosecutors in every jurisdiction. If he invokes his Fifth Amendment right against self-incrimination, he explicitly hands prosecutors a detailed roadmap of his vulnerabilities, allowing civil juries to draw massive adverse inferences that will cost him hundreds of millions of dollars. If he lies to protect himself, he instantly generates airtight perjury charges that are shockingly easy to prosecute because the lie and the contradicting document are simultaneously entered into evidence. There's simply no version of sitting in that witness chair that does not culminate in utter legal devastation. This inescapable reality is the exact reason his defense apparatus has spent decades and fortunes ensuring he never had to sit there. The violently compressed deadline was explicitly engineered to completely neutralize his one true superpower, the manipulation of time. He cannot file an appeal and simply wait. He cannot utilize the standard legal tools of delay. The judge has specifically assessed his lifelong history of stalling, misrepresentation, and bad faith litigation and concluded that extreme, uncompromising measures were required. The explicit threat of US Marshal custody is a calculated judicial statement regarding the expected likelihood of non-compliance, and it ensures that the public cost of defying the court will be completely devastating. Every possible option leads to ruin, and none of them can be spun away by aggressive press releases or social media outrage. The formal legal record created by his testimony, his silence, or his arrest will exist permanently. The 4-decade strategy of outlasting the justice system has finally crashed into a judicial wall it cannot breach. There is no next motion. There is no pending appellate ruling to save him. There is only the ticking clock, the empty witness chair, the looming oath, and the inescapable reality that the final defining chapter of his legal existence is about to be permanently written in the next 72 hours.